Today's podcast is part two of Should I Do an EEO Rebuttal Statement? Now, since the first podcast, that was back in 2021, where we've covered this issue in part one, so to speak, I have learned many additional factors that I believe are important in deciding whether one should submit an EEO rebuttal. I'm going to share them with you here in part two. And principally, this comes from a large increase in the sua sponte summary judgment motions that administrative judges are filing. So here's just to set the background. What happens is the ROI is finished. It then goes to an administrative judge if there was a hearing request made. And before anything happens, what these judges are doing is they are issuing on their own sua sponte summary judgment motions. We've got to get rid of this case because many of them have too many cases, and this is a way that they can lighten their caseloads. And as I've said, there are some administrative judges I have deep respect for. They're very good. There are others that are not so good. And you have to be aware of your case having the potential to being dismissed on one of these sua sponte summary judgment motions. So because there are many more of these sua sponte summary judgment motions, that is now a factor in whether one should do an EEO rebuttal statement, whether one should do multiple ones for each witness that has testified in an affidavit, and how to do those. Let us take a look at the four basic arguments that an administrative judge is going to raise in a sua sponte summary judgment motion. The first one, there was a missed deadline. The second one, there is no similarly situated employee. The third one, there's no adverse action. Whatever happened to this person didn't rise to the level of a tangible action. The fourth one, what I like to call the RMO interrogatory dump, which basically means that what the administrative judge has done is taken everything the responsible management officials have stated in their affidavits and has demanded that you respond to each and every one of those statements. Let us go through each of those arguments. Okay, so the first one, a deadline is missed. What legally postpones a deadline? Let's say someone missed the 45 days and the agency did not yet dismiss the case before the report of investigation was completed, which many times they do. Let's say someone was incapacitated, someone was sick, someone didn't get the mail, whatever the story is, generally that's going to be a question of law. And I would leave that out of any rebuttal statement for now. I would, unless it's an obvious thing, you may want to talk to an attorney about putting that in or not. But usually there is no explanation as to why a deadline is missed. There shouldn't be anyway by an employee on an ROI. Second one, no similarly situated employee. That's a question of law, and what the AJ likes to do is say, well, even though guy one was the person doing the intake of the reports, and guy two was the person who interviewed the witnesses of whatever investigation he was doing, well, those jobs are different, and because they're different, the supervisor has the right to treat one, a white guy, like a king, but he can treat the black guy like a dog because they have different jobs. Okay, obviously that's going to be an issue in a case. Did the employer failure to follow established procedures or criteria is going to be a question of law. And what you should do is gather these policies that supposedly protect you. Each agency generally has some policy statement or something that says whether you're a janitor, a computer IT person, a manager, it doesn't matter. Everybody here is entitled to work in a hostile, free environment. And that's going to be something that you're going to have to address, or that you should address one of these rebuttals. Third argument, no adverse action. Whatever happened to you hurt you financially? Generally, that's a question of law. I believe we have a couple other podcasts that talk about this recent DC case law of Chambers versus the District of Columbia, where the District of Columbia has opened up and has loosened the definition of adverse action, and that's something that you're going to want to prepare for. What I would like to talk about in some detail here is the fourth, the RMO interrogatory dump. Okay, now take a look at this. This was a page taken from one of these sua sponte summary judgment motions. And what I've done is I've redacted the names of the people here. And you can see what this judge has done. Is this judge has basically said, look, here's how I'm going to get rid of this case. I am going to take everything that the RMO has claimed, all 30 pages of that person's affidavit, or however many pages they were, and I'm just going to throw that out there. And I'm going to make the complainant respond to each and every one of these statements within 15 days. Okay, how does somebody do that in 15 days? I mean, let's just run the numbers on that. Number one, it's going to take someone generally at least a few days to get a consult. I know here we try to move those at the head of the pack, so you can generally get one within a day or two, unless I'm on trial for something like this. After that, it's going to take another day or so to sign up. You're then going to have the attorney being handed an ROI with, could be 1,000 pages, 1,500 pages. All of that has to be reviewed by somebody. Generally, we try to have one of our law clerks do that, who bills at less than half the rate that I do. You're talking about, yes, we will make a motion to continue the deadline for an extension. Usually you'll get one for a couple weeks, something like that. You're talking about working under a good deal of pressure to go ahead and to rebut every single one of these statements within a very compact time period. How many law firms are practically going to do that well? I have colleagues who I respect very highly. I have colleagues who I don't. You're talking about the way easier way to do this is to work with a law firm while the ROI is going on, while that investigation is going on. When you get those rebuttals, when you get the opportunity to rebut something one of your RMOs has said in one of those 30-page affidavits with the hundreds of facts, okay, you want to be doing that. And you can it's easier to get extensions from the investigator than it is from the judge. So what you want to do is you want to work with that. Like, so for example, if we turn back to this page, number 15, all right, where AC is the RMO, and the RMO goes through this whole 7 or 8 different facts within that paragraph. So you want to work with a law firm, someone who kind of understands. In your rebuttal, what you're going to want to do is you're going to want to say, the AC claimed this in paragraph 15. Here's my response to that in paragraph number 15. And you do it line by line. Okay, now the AJ gets that ROI and looks at all those statements, but he's also looking at all the rebuttals, and now the guy's thinking to himself, well, this case is not so easy to get rid of, because even if I do one of these RMO interrogatory dumps, it looks like these guys are ready. And what's that going to do? The other reason that you may want to do this is at the initial conference with the administrative judge, if you have all of those facts already lined up, and the AJ is going to think, well, you know what, there's really only one way to get rid of this case now, and that's going to be to pressure the agency to settle the case, which is what should be happening on these injustices. So this is a type of thing where new information, new facts, you kind of take what's out there in the environment. In psychology, it's called the mastery or environment mastery. And you're just basically saying, okay, look, that's the environment. How do I turn this to help me and as a benefit, as an advantage for me in my case? We invite you to become a subscriber of this channel and watch all of our podcasts. And if you're in the middle of a report of investigation or you have any sort of employment matter, contact our office. We are there to help you.